So this is, will you be compliant if the ATO comes knocking on your door? I think it's a pretty, hot topic at the minute, given what's happened in the last few years. So it's a presentation from Mathew Brittingham from Tributum Law. He's got a half-hour presentation. At the end, we'll take some questions from the floor. I think we're going to dive straight in just to make sure we have time to get through everything. So hand straight over to you, Mathew.
Thank you. Cheers. Afternoon, all. So what I want to talk about today is the current excise issues that you'll face if the ATO comes knocking on the door, and at the moment they're knocking frequently and loudly. So chances are, if you're in this industry, you'll get a knock on your door fairly soon. Being a lawyer, of course, you always got to have your disclaimer up front that this is just a general presentation. If you have any specific circumstance, you've got to come to lawyers so they can actually get paid. But I will cover off on things that are quite pertinent, and will give you hopefully a decent insight into what's actually transpiring. So by way of overview, what I'd like to talk about today particularly is the eligibility criteria with the excise remission scheme. This is obviously a very hot topic at the moment. I've acted for the alcohol industry for many, many years, and there was a similar thing with the wine industry when there was an expansion of the wet rebate. It I wouldn't say it's getting abused necessarily in excise circles with the remission scheme, but there was a plethora of claims and led to a huge amount of audits by the ATO, and we're seeing a similar thing now with excise. Particularly a couple of areas I'll focus on is whether you're the manufacturer, which as you'll see is a big issue if you're contracting with third parties. And of course, do you meet the legal and economic independence test, which is on everybody's lips at the moment following the release of the recent tax ruling. What I'll do is also give you an insight into other areas that I'm seeing in practice. So I normally get called in once people are under audit, and I had 3 yesterday, new instructions come in. So just on audit matters alone. So it's very busy at the moment, so I'm getting to see on the front line what the ATO are targeting. I'll give you a bit of an insight into that, particularly in relation to destroyed products, claiming remissions on them, and bonus stock. Also, we'll have a look at product classification. This I see is going to be a big issue with the plethora of new funky type products out there, and whether they're classified as beer or other excisable beverages, and there's big implications in that space. And finally, there's also a lot of restructuring going on at the moment in the excise industry. I'll give you a few tips and pointers from tax savings that you can get if you are selling or bringing investors into your business, but that'll be a fairly short part of the presentation. So why is all this important? This is sort of the wake-up call, and it's really, really important with excise, because if you claim the excise remission when you're not entitled to, you can be taken to evade excise, and what that means is it's an offence, so it's actually an offence under the Act, and you'll have to pay a minimum of 2 times the excise evaded, but potentially up to 5, or if the court can't work it out, 156,500. So what that means is if you take 2 years, you've claimed 350. If you did it illegally, you have to pay back that's 700, plus you can be a minimum another 700 on top of that, so you're up to 1.4 million. If it's 5 times, you could get a bill over $4 million. So this stuff's important. Not many businesses I know are going to be able to survive those sorts of penalties. That's just the beginning. It gets worse. If the ATO considers that you've been intentional in evading your excise duties, or reckless, just complete abandon, didn't really give a rat's toss about it, then it gets significantly worse, because you can be incarcerated, which no one wants to be, and you have a minimum of 5 times the amount. So this is important stuff. The penalties in excise are actually much higher than under most of the income and GST tax provisions, because it's one of the government's rivers of gold. So they treat it very seriously. So at the moment, just to make you feel even better, there is a massive increase in audit activity. As I said, I had 3 instructions alone yesterday for new audits that I'm going to have to act in for people under audit from the tax office. So that's just in one day. So it's they're going to be doing a big sweep through here on excise issues. So it's going to come. particularly on the excise remission claims, because they will probably already see a plethora of additional claims being taken. So they'll try and stamp that out and make an example of a few people. So you best to get your house in order now before the ATO come to you. So if we look at starting with the excise remission, the eligibility criteria, you have to have manufactured. Now that just may seem fairly standard, but actually is quite an issue in a lot of cases, the actual beverage in which you're trying to claim the remission. And then you have to have a liability for excise, and you have to bring in home consumption. So if it's sitting under bond in a warehouse somewhere, you can't claim a remission on it, which I've seen some people try to do. So that's the first, what I call fundamental step, but a lot of people even miss out on that. The second big one is that you are legally and economically independent of other manufacturers who receive remission. So obviously this is a big issue with the recent release of the tax ruling. You also have to have fermented 70% of the alcohol, distilled it. This can be a problem with RTDs, as we'll see shortly. And finally, if you are distilling, you have to own the still. I won't talk about that much, because it's fairly straightforward, but there's sort of the fundamental criteria you have to satisfy. So looking at the manufactured criteria to begin with, you have to have an excise manufacturing licence. That's step one. You can't get a remission without that. Then you have to be in control of the processes, even if you have a third party, which we'll talk about shortly. So you can't just do it from your laptop. You've got to be in control of the processes from cradle to grave, from production to packaging, the whole lot. And very importantly, it has to be in premises that are nominated in your excise manufacturing licence, which, as we'll see shortly, can create an issue with contract processing. And of course, it's another offence if you manufacture goods at premises not listed. So getting your licensing requirements in order is very, very important. One of the first things the ATO will look at when they come to have a look at your affairs. So this is probably the most important part of this aspect, is if you're dealing with a contract processing, which I get getting questions on this all the time in the industry, by the way. This is a huge area at the moment, because a lot of parties don't have capacity, or it's like similar in the wine industry. I think there's 10 winemakers for every production facility, and it could be a similar, well, maybe not quite as much, but there's obviously a lot more brewers than there are breweries or for premises to manufacture. So, and it can be very, very difficult to prove that you satisfy this first criteria if you're manufacturing under contract. You'll need to demonstrate you've actively participated. You can't just do it from your desktop. You've actually got to go and be involved. You have to supervise and direct, again, same principle. And you have to have control of the manufacturing process. You can't leave control to the contractor. So essentially the contractor's only really there to provide the basic inputs like licensing of equipment, premises, and maybe a few staff. They're doing much more than that. You start treading a fine line of being ineligible. So let's have a look at an example which I may or may not have seen. We've got local beer co. So they've run out of space. They can't manufacture all their range. So they contact large beer co to manufacture 2 products they can't do from their own facility. And local beer co, they provide the recipes, all the IP, all the ingredients for each product. The contract says they'll own, the product from start to finish. So looking good on paper. And large beer co will employ its own staff, and importantly, are contracted to provide a set quantity of beer. And that's important, as we'll come to see in a minute, because that almost makes it eligible to begin with. So despite the fact that on paper you look like the man, you own all the ingredients, you provide the rest, you have all the IP, it's highly likely that local beer co wouldn't be a manufacturer in this circumstance. It does not provide supervision. As I say, you've got to be on the factory floor directing the troops. It doesn't have control because it's left it all up to large beer co. And as I was saying, just with the quantity, this is important because if you're producing for a set quantity, you'll guarantee that, so you don't have responsibility for waste and spillage, which would normally be a manufacturer's responsibility. So these are all concerns as to why it wouldn't happen. But there is actually even one significantly bigger problem here. I'm not sure if anyone has picked up on it. It relates to something else I said earlier. No takers? There's no indication that local beer co has a licence to manufacture at that premises. They're just out straight away. And if I could leave with one point, one huge take-home point from this is this fact is that you cannot claim the excise remission if you're manufacturing at premises not included in your excise manufacturer's licence. That would be the easiest wipeout for the ATO ever. But I can absolutely guarantee you, London to a brick, there'd be lots of people doing that right now. Hopefully no one in this room. So this begs the question, well, can you even get a licence over a third-party premises? I sort of will give a slightly obtuse lawyer's response here and say, well, yes, it is or it might be possible. But you'll probably need to get a designated area within the facility, so you need to find someone with excess space. There is another potential way of doing it, which I haven't included there, so it's like much more problematic, but you could have like a rolling time frame where you're in and out of another facility. Could be another way of doing it, but that could be. I'm not sure that's got complete blessing by the tax office yet. You'll basically need to licence the equipment you're using, and tax get a contract over certain staff. And you have to have your own senior employees, like the senior beer maker, on site. However, it's very nuanced, technical and difficult, and I'd certainly wouldn't recommend going down that path without getting professional advice to begin with, because you could spend a lot of time and effort and get nowhere. So it's very, very important that that you get proper advice if you're going to go down that route. So that's dealing with the first major one with the excise remission. The next one is the legal and economic independence. Obviously, this is very topical, clear focus of the tax. When the tax office releases a ruling, it means they're focusing on it. So they've released their ruling a few months back after consultation, and it has two aspects, and this is where I think there's mass confusion with this right now, as people say, well, you've got two different parts. Is it a collective phrase that you've got to apply, or is there separate aspects? Well, as we'll see, you've got two. You've got legal and economic, and the ATO says you've actually got to satisfy both, and in fact, it's probably all of the above. You've got to satisfy each independently and collectively, which keeps people like me in a job trying to interpret that. But that's where it sits. But sort of if a fundamental way of looking at it is sort of on the collective side is, can you make business decisions of your own volition? Can they be independent? Are you being influenced by anybody else? If you can be completely independent in making your business decisions, then you're a long way to satisfying this aspect. So looking at the first one of legal independence, this will be a failed if I think everyone's sort of clear on that one. One manufacturer has the ability to control another through its shareholding, but this one I've seen a lot of people miss out on is that you can have an entity who's not a manufacturer at all, who controls two or more manufacturers, and then like a contagion, they're all brought in together. So I've seen people slip up on that one in the industry, so you must be careful of third-party ownership. So the relevant factors here is shareholding. The obvious one is you have a majority shareholding, that's pretty clear. Then you've got clear legal dependence, but some people think they're very clever and say, well, if I issue A-class shares, they only represent 20% of the shareholding, they carry majority voting rights, and I'll be okay. No, you won't. You will still fail because the ATO will see that, and you'll still be able to control through your majority voting rights. So don't fall into that trap, which a lot of people do. This is a little less clear, but you could still fail where you've got a majority of common board members on 2 or more boards. Although theoretically board members can wear different hats, it's very hard in practice to do that. And this one's even less and more clandestine, but one where people will get tripped up is where one board or members of certain boards are influenced by members of other boards, such as they owe money to each other in other business relationships, and probably in this space, and I've seen it in the wine industry as well. So let's say you have a scenario where you've got a brewer way past 350,000 excise remissions, turns around to brother-in-law, who's let's just say a lawyer, gullible lawyer, and says, I've got all this excess product, I've got this facility over here you can use, why don't you set up a company and you can basically produce these beers that I was producing, take over the IP, and you can sell it to my existing customers, and away you go. So that person there, and that could be completely separate ownership, no cross-financing or anything, could still be brought in, because essentially that lawyer would be reliant on the industry expertise of the brother-in-law. So that's another way that the ATO can try and join the dots with this stuff. So you have to be careful of that as well. Coming to the second limb of economic independence, this test will be failed if one manufacturer is financially reliant on the other, which is fairly obvious. And again, you have that same third party. If there's a third party who is pulling the strings, you can be brought in here as well. The factors that are important here is distinct facilities. Obviously, if you have shared facilities, that creates a degree of closeness, which the ATO would look at in an interesting fashion. Independent processes and products. So again, you need to basically show that you have control over the processes involved in manufacturing, packaging and labelling, and that you have your own customs and sales network. So coming back to that example with the brother-in-law that I was saying, that person's never been in the industry, they've got they haven't been to conventions like this, they're relying purely on somebody else's customers and sales network. Independent finance or inter-entity loans are a pretty clear example, but another one here which can bring you in as well is that if you're supplying goods between another entity, you don't demand payment. That can be taken to represent financial assistance, which could also show economic dependence and bring you unstuck. Another one is doing a JV with another producer. Again, you might not have any co-ownership or finance, but if you're entering into a joint venture together, they may say that you're no longer economically independent because you have an economic reliance in the joint venture. So you just have to be careful of this as well. And finally, independent staffing. You've got to have your own staff, you've got to hire, fire and manage them, but you can have common personnel, but they'd have to be under separate contracts and work for each brewer at separate times. So if you have a particular beer maker that you want who's working for someone else, you'd have to enter into your own contract with them and have them working at different times to the other brewer. And of course, separate accounting record, that's kind of fairly obvious. Every business has to maintain separate accounting records. So here's an example, and this one I think sort of encapsulates a lot of the issues that I've seen in a fairly simple form. So a bit of relief with the diagram as opposed to text, but so here you've got Brewco 1 and Brewco 2. Now neither has ownership interests in each other, so there's no association there. Brewco 1, its major shareholder is Teresa. Brewco 2 is Christine, so there's not the same third party with legal ownership. And often people stop at that point and think they're okay. But you've got James Co there, he's a minor shareholder in both, but has given financed 100% to both entities on an interest-free loan. So clearly, those entities are reliant on James Co for their economic ability to survive, and therefore they'll be joined together. So you have to be careful wherever you're getting third-party financing, other than independent finances like banks, and then if you're getting it through investors who want to come in on debt as opposed to equity, you've just got to be very careful. The testing period is obviously, if you're trading, it's got to be continually, but if you are, this is just a point to note, thinking of bringing in or not being economically independent, if you're going to have a restructure later in a financial year, if you make claims early in the financial year knowing that, then arguably you're not going to be able to satisfy that criteria of having a reasonable expectation that you'll be independent for the remainder of the year, and you may have to pay back plus the penalties that we spoke about in the excise claim. So if you are thinking of doing a restructure within a financial year, just be very careful before you claim excise remissions. If you think that would result in you becoming economically or legally dependent with another existing brewer who's claiming remissions. The ferment or distill of alcohol requirement, I'll go through this pretty quick. Essentially, it relates to the same problem back as manufacturing, is that if a third party is doing this, then they are doing the manufacturing, you might not be taken to distill. So in that local beer co example earlier on, he wouldn't have been taken to distill, so or ferment. So in that case, the beer base, they wouldn't satisfy this requirement. But you have to also be careful here with RTDs. If you're just buying the ethanol and then blending it with flavours and soda to make an RTD, you may not satisfy this requirement either. So just be very careful with that. So that covers off on the eligibility criteria. That was a fair chunk of the presentation on that. What I'll do is move through these last bits fairly quickly. These are the things that I'm seeing in practice right now. So the ATO is going after, we're looking very closely if you claim remission on destroyed goods. It shouldn't be a complete surprise because they did make a taxpayer alert about this a couple of years ago. But the concern here is you apply and get your permission to destroy goods on the basis they're unfit for human consumption. Someone's told a porky pie and they're not. And the goods are not destroyed. They're instead repackaged and sold. And of course, then they can be sold at a much cheaper price than competitors in the market. There's no excise on them. So obviously that causes the ATO a lot of umbrage because they, one, are getting no excise or less excise, and two, it's distorting the market, which they don't want to occur. So I've seen them go into extreme detail. This went on for about 6 months for a client I acted for. They wanted photos. If you're getting it destroyed off-site, they wanted evidence of that. So you really do need to keep if you're getting things destroyed, make sure you have a really good evidence base on it. Otherwise, they'll draw their own conclusions, which may be unfavourable to your scenario. But if you have the evidence, also, these audits go on for a long time. If you can give the ATO the information in a clean, concise form quickly, that builds confidence, and then they're less likely to want to dig deeper. So bear that in mind. Bonus stock also in that tax alert, it's a sort of a similar scenario. You say you'll sell a whole lot of bonus stock, but the invoice doesn't reflect that as actually what's delivered, so it's not actually put through the books. So again, results in a whole lot of bonus stock being supplied without excise. Again, same problem. Cheaper price, no excise, ATO doesn't like it. So that's probably less I see, but it's still there on the odd occasion. Finally, nearly finally, we'll look at product classification. I see this is not a huge focus of the ATO yet. It has been in wine, the difference between a wine product and an other excisable beverage, but I think it will come in with beer as well. So beer is defined, as we know, in the Excise Tariff Act, and if you look at the title, it's 1921. It may have been some amendment, it's fairly standard, and essentially that's probably based on what we'd call a traditional beer product. But in the last 4 or 5 or slightly longer years, there's been a plethora of what I'd call non-traditional products where people would be trying to put them under the beer definition. So I'd be careful on whether they actually satisfy that definition, because if they're not, they're another excisable beverage, and what that effectively means is, so if we look at 3.5% ABV, for beer, if it's for retail sale as a packaged product, $59, kegs $41, but if it's another excisable beverage, you're basically doubling the excise. So if you come back and get audited a few years later, you can have a massive bill for unpaid excise if you've got the classification wrong. So I'd be careful with that. And in the last minute, if you're selling businesses, this is the positive part of the presentation. It's only one slide. There is some relief. Income tax is probably a little better. If you are selling, there are things called the small business concessions, which it's good to get advice on, because if you do have built-in gains in your business, if these do apply, then you potentially can save. Well, I've acted for clients, where I've saved them $2 million. I've just eliminated or greatly reduced their tax liability. One bought a new house in AMG, a lot more than he paid me, but anyhow, that's how it goes. If you're selling as a going concern, then you can avoid GST, which would also potentially reduce duty. And on the duty side of it, if you're not selling land, then often you won't have to pay duty, which can be a big saving. But conversely, if you are selling land, then even if you sell shares, that can give rise to duty, and also duty on the non-land assets will be brought into duty. So if you're selling land, you just got to be careful of duty. Another one I'm seeing here is that if you want to bring in an investor because you're carrying a lot of debt, people think, well, if I get the investor, I'll issue them shares on the basis they're going to assume some debt and I'm not going to pay CGT, or if I transfer some shares because I'm not getting any cash. It doesn't work like that. You get a deemed market consideration based on or for the amount of the assumption of debt, and you'll still pay tax, and it's a bad situation then, because you're paying tax on a value that you didn't receive cash for. And finally, if you are bringing in an investor, just always bear this in mind, that you may be triggering the legal independence bit, so you may actually undo the benefit of bringing somebody in because you might lose your $350. I've seen that happen as well. So that's it. There's a fair bit covered in a fairly short session. I'm sure you get the notes and everything, but if anyone has any questions, I think I've gone right on or over time.
No, yeah, people are happy to.
Thanks, Matthew. If, what was it called, Large Beer Co. is contract brewing for local beer co,
Yep.
And local beer co is not entitled to claim a remission because it's not their premises, what liability does Large Beer Co have for the unpaid duty?
Well, it should. Well, in theory, it shouldn't, because it doesn't actually have ownership of the product under that arrangement. But it is a good question, because the ATO would certainly look potentially to wangle a way in, particularly if Large Beer Co is the one with the assets. But I think it would be unlikely. But it all depends on the terms of the contract. So it can be done. But if you are doing it, you'd certainly need to do that. Well, the other way of potentially doing it as well is have it under continuing movement permission, where it doesn't actually come out. So it come out of local beer co's warehouse, where the excise duty would give rise to. So I think there are ways of protecting yourself. But yeah, you would want to get advice before doing it.
Any other questions yet, Kyle?
Yeah, just on the movement permission, does that protects Large Beer Co? Is that what you're saying? Sorry.
It could, yeah, because it wouldn't. They're not at that point. They're not going to be up for the excise position. But yeah, if you have a scenario where Large Beer Co is warehousing and then they are calling it at a point of sale, then I think that you could run into issues, because then it's coming from their premises. and whether then they're going to be brought in under some sort of joint liability scenario. It's unlikely, but basically the ATO would work on pinning local beer co first, but when they realise if they don't have any assets, it's when they start expanding their wings.
Anyone else? Oh, yeah.
Given the current number of VAs that are going on in the industry, how likely is it, do you think, that the ATO will start regular audits of companies? And is there anything that can trigger an audit, in your opinion?
Yes. I think we're already in that territory now where the ATO realise, especially on the basis of the remission, that they need to do auditing more regularly. But for some of my bigger clients, they're getting audited. When we've just undergone an audit, and I'm actually going to have to write a fairly scathing letter, I think, next week, but which completed with no issue, and now they come back 2 months later with permission to bring Spirit in and are questioning that. So when they've just audited all these things, so they're very hypersensitive about things at the moment. I think things that will spark their interest, it was very similar when the producer rebate came in for wetters, that when a new entity starts up and creates a remission very quickly, I think that would lead to an audit of that, which then once they get their teeth into one which has gone wrong, that normally links the dots and then they start going for everybody. So that's a big way in.
Okay, a question at the front.
Those independent tests, do they come back to the natural person involved? For example, if I've got multiple entities doing the financing, the leasing, the equipment, are they looking at the entities involved for those independence rules or the natural person behind them all?
They can go back, but it depends. So what, when you say that, when you say you've got multiple entities, so you're saying you've got different entities doing brewing, different doing financing, is that what you're saying?
Well, the brewery rents from one company.
Yeah.
It leases the equipment from another company.
Right.
It's got financing from another company, all of which I control.
Yeah, but is that only for yours, or is that, well, that's, I don't see that being a problem. Basically, it only comes back if you're doing that for other manufacturers as well.
Yeah, and a flow on, if Westpac is lending to multiple breweries,
yeah, that's a question that gets asked a bit. The answer is no, there's not a problem. But in theory there is, but in practice there's not.
Cool.
Yeah.
Anyone else? Or is it lunchtime? Okay, great. Oh, no, one more.
Yeah, we actually built an Excise calculator for some of our clients, and the one thing that we found, you were talking about that sort of free stock thing, is we had actually built it originally off invoices, and we found that that's actually not a good record to track it on. You should actually be looking at a movement record because the ATO wants to track it on movement, and that leads to sort of where a lot of breweries have stock sitting at third-party logistics, so they move it from their own bonded location to a 3PL that's bonded. What are the implications there for excise? Do they have to? They still don't have to pay excise once it leaves the other bonded location, or are they liable once it leaves their own premises?
The liability arises when it's brought in for home consumption. So generally the movement permission is there to basically shift it where it's not being moved to bring brought into home consumption.
So they'd have to have a movement permission to move it to a 3PL?
Yep.
Okay, cool.
Okay, great. All right, thanks then, Mathew. I guess people can head to your website or
if you have any questions
outside the room at the end, or
please. Sorry, what was that?
Or will you hang around for a chat outside?
I'll be around for lunch. I was, and I'll be at the awards tonight. I was hoping to spend a bit more time this afternoon, but unfortunately, ATO has ruined that. So I'll have to work a bit this afternoon. But yeah, I'll be. If you don't catch me now, tonight, or alternatively, you can ring me or email me. And always happy to help.
All right, that's great. Thank you very much. All right.
Cheers.
Enjoy everyone.